Today's tech news moves fast, but understanding it shouldn't be hard. That's why Snarful Solutions Group brings you Connecting the Dots, where we break down what's happening in tech and why it matters to you. Now, let's dive in with your hosts.
Good morning, everyone. I'm Alex.
And I'm Morgan.
Welcome to Connecting the Dots, broadcasting live from Snarful Solutions Group, right here in very sunny Sacramento, California.
Very sunny. It's gorgeous out today.
It really is. Today is Thursday, March 26th, 2026, and we are absolutely thrilled to have you with us this morning.
Yeah, thanks for tuning in. And before we get to our main story, which, by the way, is a massive legal earthquake that could literally force the entire internet to redesign itself, we should probably do a quick vibe check.
Yeah, let's get you caught up on the Morning Star. That's our Snarful Tech article report quick hits. So, looking out the window, like we said, beautiful day in the capital.
Definitely. Mostly sunny skies and a high of about 78 degrees in Sacramento today.
Perfect weather.
But if you're tuning in from the mid-Mississippi or the Ohio valleys, please, see weather aware today.
Yeah, it's getting rough out there.
It is. There are severe thunderstorms rolling through later this afternoon and evening. We're talking large hail, damaging winds, and even a few possible tornadoes. So keep your alerts on.
For sure. And out in the plains, they're dealing with sort of the exact opposite problem. Record warmth across the southern tier is creating some really serious fire weather conditions today.
Right. So stay safe out there wherever you are.
Moving on to the markets. Well, it was a bit of a red day across the board yesterday.
Yeah, a little sluggish.
Just a bit. The Dow closed at 46,210.09, which is down about 0.25%. The S&P 500 closed at 6,538.12, also down roughly 0.25%.
And Bitcoin took a bit of a hit, too, actually. It closed down over 2.5% at $69,372.84.
Not the best day for crypto. And finally, for our local sports fans, it was kind of a rough outing for the SF Giants yesterday, too.
Oh, man, don't remind me.
I know. They dropped their game against the New York Yankees 7-0.
Ouch.
Yeah. Max Fried took the win on the mound for New York, and Austin Wells had a pretty great day at the plate, going 2 for 3. But hey, we'll get him next time.
Fingers crossed.
Now, if that Giants score or, the stock market has you feeling a little sluggish this morning, I have exactly what you need.
I think I know where this is going.
You definitely know it. We want to give a huge shout out to our sponsor, Strong Coffee. If you are tired of that mid-morning crash, you really got to try this.
It's so good.
It is a premium instant coffee, but I swear it tastes exactly like a fresh traditional brew.
Yeah, you wouldn't even know it's instant.
Right. And the secret is that it's packed with 15 grams of protein, MCTs for brain fuel, and adaptogens like ashwagandha.
Which is key, honestly, because it gives you that clean, sustained energy.
Without the jitters.
Exactly. No jitters. You just mix it with water and you're good to go.
It's an absolute game changer for early mornings. And right now you can use the promo code SNARFUL, that's spelled SNARFUL, for 20% off your entire purchase at strongcoffeecompany.com.
Definitely check that out.
Okay, let's get into the core of today's show.
Let's do it.
The entire foundation of the modern internet is basically built on keeping our eyes glued to the screen.
Right. Oh, 100%. Attention is the currency.
Exactly. But yesterday, a jury in Los Angeles basically ruled that this very foundation might be illegal.
Yeah, we are watching the entire legal framework of the internet being tested in real time right now.
It's wild. Our mission today is to connect the dots on what 2 distinct back-to-back trials mean for the future of the internet. We're looking at how families navigate online safety and, honestly, how tech businesses are going to operate fundamentally from here on out.
So let's dive into what happened in LA first.
Yeah, lay it out for us.
So yesterday, a jury ordered Meta and Google, specifically YouTube, in Google's case, to pay $6 million to a 20-year-old woman named Kaylee GM.
And how did that break down?
It breaks down to $3 million in compensatory damages and $3 million in punitive damages. The jury basically found that these apps were negligently designed to addict children.
Wow.
Yeah, and that this negligence was a substantial factor in causing Kaylee severe depression and body dysmorphia.
And they actually split the liability between the companies, right? Which I found super interesting.
They did. And it's quite revealing about how juries view different platforms right now.
Yeah.
Meta is on the hook for 70% of that total.
And YouTube is 30%.
Exactly. Now, naturally, both companies immediately stated they plan to appeal the decision.
Of course. I mean, they aren't just going to roll over.
Right. Their core argument is that mental health is profoundly complex. It's influenced by genetics, family dynamics, childhood trauma, Yeah. All sorts of things.
They're saying you can't just point a finger at Instagram and say that caused it.
Exactly.
Yeah.
They argue you simply cannot link a medical condition to a single app.
Yeah.
And Google also heavily leaned into the defense that YouTube is a, responsibly built streaming platform.
Not a social media site.
Right. They really tried to distance themselves from the social aspect entirely.
Okay, but I want to talk about this one specific moment in the courtroom because the optics of it were just incredible.
Oh, the M&Ms.
Yes, the M&Ms. So the plaintiff's attorney, Mark Lanier, is arguing for punitive damages, right? He wants the jury to really punish these trillion-dollar companies.
So he brings out a prop.
He brings out a giant glass jar filled with 415 peanut M&Ms.
It's a brilliant piece of courtroom theater, honestly. He used those 415 M&Ms to represent Alphabet's, which is Google's parent company, their $415 billion in stockholder equity.
So he stands there, looks right at the jury, and says, "What are you going to fine them? $1 billion." And he plucks one single green M&M out of the jar.
Just one.
Just one. Then he says $2 billion, and he pulls out another one. He visually demonstrates that fining these companies $1 or $2 billion is like taking a single M&M from a family-sized pack.
The executives won't even notice it's missing.
Right. His exact quote to the jury was, "You've got to talk to Meta in Meta money."
Which perfectly highlights the sheer scale of the financial disparity in these cases. I mean, a $6 million verdict is literal pocket change for Meta and Google.
Yeah, they make that in, seconds?
Exactly. But the dollar amount isn't the point of this trial at all. The point is the precedent. This is the first time a jury has legally declared these platforms to be defective products.
Okay, wait. I really need to stop you there because I am genuinely confused by this legal strategy.
How so?
Well, for decades, tech companies have had this impenetrable shield, right? Section 230 of the Communications Decency Act.
Right, the holy grail of tech law.
Yeah. And the way I've always understood it is that it's kind of like the phone company. You can't sue AT&T if two people use their phone lines to plan a bank robbery.
Because AT&T just provided the wire.
Exactly. Section 230 says tech companies just provide the digital bulletin board, so they aren't liable for what users post on it. So how on earth did this lawyer get around that massive legal shield?
That is exactly the crux of the issue. You're completely right about Section 230. It protects platforms from liability regarding user-generated content.
Right.
If someone posts a harmful video, the platform isn't legally responsible for the video itself. But the plaintiffs in this LA case completely bypassed the content.
Oh.
Yeah, they didn't sue over the call being made on the phone line. They sued over the engineering of the phone itself.
Ah, so they targeted the architecture.
Precisely. They argue that features like the infinite scroll, auto-playing videos, and intermittent push notifications aren't just neutral tools.
They have a purpose.
Right. They are intentionally designed to exploit human psychology. Take the infinite scroll, for example.
Okay.
In the physical world, when you read a book or a magazine, you eventually hit the end of a chapter or the bottom of a page. Your brain gets a natural satiation cue.
A stopping point.
Exactly. A stopping point that says, okay, I'm done here.
Right. You have to physically turn the page or close the book. It requires an active choice to continue reading.
Exactly. But the infinite scroll removes that stopping cue entirely. It continuously loads new content before you even reach the bottom of the screen.
It just keeps going?
It just keeps going, bypassing your brain's natural impulse to move on to another task. The plaintiffs argued that this isn't a neutral bulletin board at all. It's an architecture designed to chemically addict the user by dripping dopamine.
So going back to my analogy, it's not that the phone company connected a call for bank robbers. It's that the phone company engineered the physical receiver to inject a highly addictive substance into your ear every time you pick it up.
So you never hang up.
Guaranteeing you never hang up. That makes so much sense.
That's exactly it. And the specific analogy used in court was the digital casino.
Oh, like slot machines.
Yes. If you put a teenager in front of a slot machine that is psychologically engineered by experts to keep them pulling the lever, you don't blame the teenager for getting addicted.
And you don't blame the pictures of the cherries on the screen either.
Right. You blame the casino for the design of the machine.
And when you look at the internal documents they presented at trial, that casino analogy really holds up. It's actually damning.
It really is.
There was an internal memo showing that 11-year-olds were 4 times as likely to keep coming back to Instagram compared to competing apps, even though the platform's minimum age is supposedly 13.
And another document literally said, if we want to win big with teens, we must bring them in as tweens.
win big with teens. I mean, it strips away the whole defense that these architectural choices were accidental or just meant to, improve user experience.
It frames the intent as predatory. And this legal strategy, arguing negligent design rather than moderating speech, it successfully circumvented Section 230.
Because the jury wasn't judging the videos.
Right, they were judging the engineering.
Now, if you think the psychological design is a problem, wait until you hear what happens when the digital safety nets completely fail.
Yeah, this is where it gets even heavier.
This brings us to what happened in New Mexico, literally just 24 hours prior to that LA verdict. We are moving from addictive architecture to a catastrophic failure of basic safety infrastructure.
Right. So on Tuesday, a jury in Santa Fe hit Meta with a massive $375 million penalty. And this wasn't a private citizen suing, like in LA.
No, this was the state attorney general, Raul Torres.
Exactly. The jury found Meta violated state consumer protections by misleading parents about how safe Instagram and Facebook were from child predators.
And the evidence they brought to court was incredibly dark. The attorney general's office ran this undercover sting operation. They called it Operation Metafile.
Yeah. Police officers created fake profiles, posing as children on Facebook, Instagram, and WhatsApp.
And the results were horrifying.
The attorney general testified that the fake accounts were simply inundated with explicit images and targeted solicitations from adult predators.
It wasn't just a trickle, it was an absolute flood. And it resulted in actual real-world arrests.
But here's the part that genuinely blew my mind. During the trial, defense attorneys brought Meta executives to the stand.
We're talking top level, right?
We're talking CEO Mark Zuckerberg and Instagram head Adam Mosseri testifying under oath. And their defense essentially boiled down to, because their user base is so massive with billions of people, harms to children like sexual exploitation are just inevitable.
I mean, that word inevitable, it really struck a chord with the jury.
It frames the harm as just an unavoidable cost of doing business at a global scale.
I have to heavily push back on that logic. Think about the auto industry for a second. Statistically speaking, car accidents are inevitable. There are millions of cars on the road, driven by humans who make mistakes. Crashes are going to happen. But a car manufacturer can't just throw up their hands in court and say, well, accidents are inevitable, so we aren't going to bother installing seatbelts, airbags, or brakes.
That would be absurd.
Exactly. At what point does throwing your hands up and crying inevitability cross the line from a statistical reality into gross negligence?
Especially when the digital seatbelts they claim to have installed are totally failing. And that's exactly what the New Mexico jury concluded.
Because the state proved it wasn't just inevitable bad actors.
Right. The state proved that Meta's safety infrastructure was fundamentally broken. Law enforcement officials testified that Meta relied entirely too much on artificial intelligence to moderate the platforms instead of hiring enough human moderators.
Okay, let's unpack how that actually works, because I think a lot of people hear AI moderation and assume it's some super smart computer cleanly sweeping the platform, right? Why did the cops say it was failing so badly?
Because the AI lacks human context. Police testified that the algorithms generated massive volumes of what they called junk reports.
Junk reports?
Yeah. For example, an AI might be trained to flag any image with a certain percentage of exposed skin.
Oh, I see where this is going.
So it ends up flagging thousands of innocent photos of families at the beach, while completely missing a predator using coded text language in a private chat.
So it's basically drowning the human reviewers in false positives.
Exactly. It was flagging so much irrelevant material that the actual severe crimes, including child sexual abuse materials, were getting completely lost in the noise.
Wow.
The cops actually called the reporting system useless, meaning real crimes couldn't even be investigated properly because law enforcement was buried under mountains of AI-generated junk data.
So, you have a platform telling parents it's a safe environment while simultaneously blinding law enforcement with false alarms so the real predators slip through the cracks.
Yes.
It's like having a home security system that goes off every single time the wind blows or, a squirrel runs by the window.
Right. Eventually, you just start ignoring the alarm.
And that's exactly when the house actually gets robbed. It is a completely defective safety infrastructure, which honestly connects directly to the massive ripple effect we are seeing across the business landscape right now.
Yes, it really does. Legal experts are calling these two verdicts the tech industry's big tobacco moment.
I love that comparison, but let's break down why it matters to you, the listener, right now.
Let's do it.
Back in the 1990s, tobacco companies faced an existential threat. For decades, they argued that smoking was a personal choice, that nicotine wasn't addictive, and that health issues were too complex to pin on cigarettes alone. Sound familiar?
Very familiar. As we just discussed, Meta and Google literally argued in court this week that social media addiction isn't a recognized medical diagnosis, and that teen mental health is too complex to blame on an app.
But then, just like with big tobacco, the internal documents leaked.
And the public saw that the companies knew the risks.
Right. They engineered the addiction, and they targeted kids anyway. The Los Angeles and New Mexico trials are what the courts call bellwether cases.
They're the test balloons.
Exactly. They are the test balloons for thousands of similar, consolidated lawsuits waiting in the wings from school districts, parents, and attorneys general nationwide.
And here is where it becomes a true financial and existential crisis for Silicon Valley. Because a lot of people might look at this and think, well, Meta's worth over $1 trillion. They can just pay a few $100 million in fines here and there as a cost of doing business and keep operating as normal.
Right, just brush it off.
But because juries are now officially treating these platforms as defective products, it changes everything about how these corporations are insured.
Yes, let's talk about the recent Delaware court decision, because I feel like this flew completely under the radar for a lot of people, but it is massive. What happened there?
So, a Delaware court recently ruled that Meta's insurance companies are officially cleared from having to cover the damages in these specific child harm lawsuits.
Wait, I am genuinely confused here. I've owned business policies before. The entire point of commercial liability insurance is that it pays out when your company gets sued for messing up.
Right.
Why would a judge let an insurance company just walk away and leave Meta holding the bag for billions of dollars?
It all comes down to the legal doctrine of intentionality versus negligence.
Okay, unpack that for me.
General liability insurance typically covers accidents or unintentional harms. It's essentially slip and fall insurance.
Yeah.
If you accidentally drop a hammer on someone's foot, your insurance pays out.
Right, because it was an accident.
But if you purposefully engineer a hammer to seek out and smash feet, that is intentional harm.
Ah. And insurers don't cover intentional harm.
Precisely. The plaintiffs in these cases are arguing, and juries are agreeing, that the algorithms, the infinite scroll, the beauty filters, they were intentionally designed to addict.
It wasn't an accident?
No, it wasn't a slip and fall. It was a precisely engineered trapdoor. And because of that intentional design, the insurers can legally void the policy.
That is staggering. It leaves these tech behemoths financially exposed to billions of dollars in potential future payouts entirely out of pocket.
Yeah, no safety net.
If every state, every school district, and thousands of parents start winning these defective product lawsuits, even trillion-dollar companies will eventually bleed out. But let's bring this back to you, the listener. Why should you care if Mark Zuckerberg has to pay out of pocket?
Because it completely alters the internet you use every day.
Exactly. Let's say you run a small bakery and rely on hyper-targeted Facebook ads to get local customers. Or maybe you're a creator who makes a living on YouTube, or just someone who uses Instagram to keep up with their family. If these platforms are forced by the courts to physically change their architecture to avoid lawsuits, meaning they have to remove the addictive algorithms, kill the infinite scroll, disable autoplay, and verify ages strictly what happens.
Engagement metrics will absolutely plummet.
People will spend minutes on the app instead of hours.
And when engagement plummets, ad revenue plummets. The entire economic engine of the free internet is built on harvesting human attention.
It's all about keeping your eyes on the screen.
Right. So if the courts rule that the tools used to harvest that attention are illegal, defective products, the fundamental way we consume content, advertise, and run online businesses will be transformed overnight.
We are looking at a forced redesign of the global internet.
It is wild to think that a jury in Los Angeles and a jury in New Mexico might end up rewriting the code for the tools we all use every day.
It really is. This isn't just a tech story. It is a profound cultural turning point. We are definitely going to keep tracking these appeals closely because the Supreme Court is almost certainly going to have to weigh in on this eventually.
Well, without a doubt.
Now, before we wrap up today's show, we've got a great recommendation for you.
Yes, if you need a break from all the heavy tech news and want to grab something cool for yourself or a friend, we want to mention our second sponsor, Old Glory.
Old Glory is an absolute institution. They are an iconic music and sports fan merch store.
So much cool stuff on there.
Yeah. If you have a techie friend who is impossible to shop for, or a coworker who loves vintage band tees, maybe some pins and aces golf gear, or classic sports apparel, this is the perfect place to get a gift.
They really do have an incredible selection. And I actually think they have some Scony apparel too, which is great.
Oh, nice. And right now, we have a great deal for you. If you use the promo code SNARFUL again, spelled SNARFUL at checkout, you can get 15% off your entire purchase.
Just head over to oldglory.com and use the code SNARFUL.
Highly recommend checking them out. Okay, let's bring it all home.
Let's do it.
Today, we've watched the legal landscape shift violently under the feet of Silicon Valley. We explored how a jury in California ordered Meta and Google to pay $6 million for negligently designing platforms that addicted a young woman.
And doing so by bypassing the legendary Section 230 shield by attacking the app's architecture rather than its content.
Right, and we saw a New Mexico jury hit Meta with a $375 million penalty for failing to protect children from predators.
Which really exposed a dangerously broken AI moderation system that drowned law enforcement in junk data, while firmly rejecting the defense that such harms are simply inevitable.
Together, these cases represent a massive, big tobacco-style legal shift. Juries are officially penalizing big tech for addictive design and failed safety nets, treating these platforms as intentionally defective products.
And with insurers, like those in Delaware, legally backing away, the financial threat to these companies is very, very real.
Which leaves us with a lot to consider about the sustainability of the internet as we know it.
It really does.
And we want to leave you with a final forward-looking thought to mull over today. Think about the apps on your phone right now.
Just envision them.
If the courts eventually force social media companies to strip away all the addictive features, the push notifications, the endless scrolling, the algorithmic feeds, basically the very things that drive their advertising revenue, what does the internet look like 5 years from now?
It's a great question.
Will the era of free social media end? Are we heading toward a future where small businesses can't afford ads and everyday users have to pay, say, $15 a month subscriptions just to ensure a safe, chronological, non-manipulative experience online?
It's a fascinating possibility, a total pivot from the attention economy to a subscription economy.
Something to think about the next time you find yourself mindlessly scrolling. We're here to help at Snarful, so reach out on our website if you have any more questions.
That's a wrap on today's top stories. Remember, tech doesn't have to be complicated, and we're here to help connect the dots. If you've got questions or want to learn more, visit us at snarful.com. Thanks for listening, and we'll catch you next time.